right, it is 6:35 on June 29th, 2021, and we are going to open the special meeting for sexual harassment training. We are, what, how late are we? We're running 20 minutes late due to the previous special meeting running long. So we will start. If you do roll call, please.
Yep. I have trustees Chris Samples.
Here.
John Talbot.
Here.
William Luxinger.
Here.
Nathan Maas.
Here.
Jen Christensen. Here. Bill Motisi.
Here.
President Rick Worm.
Here.
Treasurer Brenda
Here.
Onabini. I clerk Sandy Maas am here. Attorney Margaret Kostopoulos.
Here.
And attorney Amber Samuelson.
Here.
Well, Margaret and Amber are running the show, so it's all yours.
We are. So I'm happy to be back. I just met Nathan. I had not met you, Chris.
You've been here on a meeting when I was here. We probably just
Okay.
did the same.
Yeah.
Nice to meet you.
And this is Amber Samuelson. She is pretty new with our firm, but not a new lawyer. So we are here to talk about sexual harassment in the workplace. And you might wonder, why are we here doing this today? And I guess it's probably a lot of reasons. One, obviously, is that with the Me Too movement, the issue of harassment and awareness of that problem in the workplace is certainly heightened. And as it should be, right? The other reason is simply it's the law. So not only should you be aware of your legal obligations as an employer and as a local government service, but you are a little bit unique because you don't have an administrator. You do have two wonderful employees who keep you running, but you are really the face of Davis Junction. It is ultimately your responsibility to make sure that the law is followed. So that's kind of why we're here today. And naturally, the legislation that I referenced, the law, requires not only that we follow it, but that we train on it and that you follow your commitments. So what are those commitments with relation to this topic? So first and foremost, you'll comply with relevant laws. So we have the Human Rights Act, which is the state version of what you might otherwise know about, which is Title VII, which is the federal law. And both of those prohibit sexual harassment in the workplace and in other places, as well as retaliation for complaining about harassment. So you are equally protected if you complain about a harassing situation or if you believe that you are being retaliated because you brought that to somebody's attention. So other commitments that I believe that you have are that you adhere to the policy which prohibits this. I know you have a policy, I know because I reviewed it. And you passed it by resolution. And again, as I mentioned, to provide training to all employees and officials to make them aware of what is harassment? How does it impact you as an employer and as a village? And how do we prevent that? So what we'll talk about today is we are gonna talk about what is sexual harassment with examples. And some of you may feel like, well, that's pretty elementary. We kind of know what that is. You know, we've seen the Harvey Weinstein stories and all that, and that certainly is. But there are other kinds of harassment that we just want to bring to your attention. Examples which might be more common than those extremes. And we want to just give you a summary of state and federal laws and what remedies they offer. We will talk about a summary of your responsibilities regarding how you prevent harassment. What do you do to investigate it, and how do you correct it? One topic I always feel is important to mention is the difference between what the law requires and what the law says is sexual harassment and what your policy says. And the reason that I always mention this is you have a policy which prevents behavior which could be sexual harassment. The features, the criteria are very similar to what the law, what courts have said are harassing situations. Your policy draws the line much earlier than the law. So you may have a situation which does meet a definition of sexual harassment, and that it could be unwanted sexual attention or attention based on your gender or whatnot, which makes you feel uncomfortable. That would violate your policy, certainly. If it's bad enough, it will also violate the law. But our goal here is not to let you get so close to that line that you may or may not be in jeopardy of being in violation of the law, which also means you're in jeopardy of paying sometimes huge damages. So we create a policy, and you have one that keeps you well aware of appropriate and inappropriate behavior and keeps you far away from that line which puts you in legal jeopardy.
Margaret, can you pull that microphone closer to you?
Oh, sure.
I think Bill's struggling to hear you.
Sorry, Bill.
Drag it towards you.
The heavy bass.
Yeah, it really is. This one should over. Okay, how about that, Bill?
That's really good.
All right, thanks. And then we'll just have some final thoughts. So I'm gonna turn it over to Amber to talk about what is sexual harassment. And this would be the legal definition of that.
Okay, so what is sexual harassment? How do I go to the next?
Oh, I'll do.
So, sexual harassment is unwelcome sexual advances, and requests for sexual favors. It's also
any other verbal or physical conduct of a sexual nature. So the first side, the unwelcome sexual advances and requests for sexual favors, pretty is self-explanatory. Any other verbal or physical conduct of a sexual nature, that's any and all which are used as a basis for employment decision, a term or condition of employment, or which interferes with the employee's job performance. I'll talk about this a little bit more, interference with the employee's job performance, because that's when you're getting into the hostile work environment. And the next, or work environment to the extent that the working environment becomes hostile. So the types of sexual harassment, you have quid pro quo, and you have the hostile work environment. And quid pro quo is this for that, you do for me, I do for you. An example would be if somebody says, if you go on a date with me, I'll give you that raise. Or if you perform the sexual favor, I'll give you that promotion. And the opposite also, if an employee doesn't go on a date with you, demoting them. If they don't perform the requested sexual favor, you give them a decrease in pay or you terminate their employment. That would be examples of quid pro quo. A hostile work environment occurs when unwelcome sexual advances, requests for sexual favors, or any type of conduct of a sexual nature has a purpose or effect of substantially interfering with the employee's work performance or results in the creation of an intimidating, hostile, or offensive work environment. So these are situations where it might not be the blatant, if you don't perform the sexual favor, I'll terminate you. It's more the constant comments, with making somebody on a regular basis feel uncomfortable, unwelcome behavior in the work environment to the point where the individual feels that it's interfering with their job or creates an environment that is hostile. So you heard me say unwelcome behavior. What is unwelcome behavior? Unwelcome behavior is uninvited, unsolicited, undesirable, and offensive. And you see on the slide, it has consent with a question mark. So sometimes it's, well, she or he didn't say anything. I thought that they consented. And consent is tricky because somebody might seem like they're consenting, but later on says, well, I went along with it because I thought I had to. I need this job. I thought that if I didn't do what I was asked, that I would lose my job. I didn't say anything at the time, but it made me really, it was unwelcome, that joke. It made me really uncomfortable, the way that my coworker, comments about my appearance to the point that I feel like I'm unable to work. So just because it's the key is that it's unwelcome. It's something that, and that's from the perception of the person who's experiencing the harassment.
And I would add here that everybody has that line that if you cross it, they're going to be offended. Some people's line is here, and that might include any mention of sex at all, or any mention of dating or appearance, and other people's line is over here, and you would have to really go through some, extra effort to offend them. You never know where somebody's line is. You could think that people are okay with your jokes, with your comments, with the way that you address them. And they might be for a while, but maybe it gets to be just too much. So my point is, you could believe that you will have a very good joking work relationship with somebody, and maybe you do, but then you just say that one word or that one story or that one joke, or you call them baby just one too many times, and then it's all over with. And to say in your defense that it seemed okay in the past is not going to cut it in a court.
Can I ask a question?
Yes.
My understanding, I guess me and you have discussed this before, but it's the person who is receiving the unwelcome behavior who determines where that line is. They get to decide what's appropriate and not appropriate, not the person speaking.
Right. So that is true, and you're jumping ahead,
Oh, I'm sorry. I didn't see it.
Sandy.
I looked.
You're skipping ahead, but you do raise a good point, which is it's almost always in the eye of the beholder. So if somebody is, you could have somebody who is not offended at all about being called babe or having remarks made about what they're wearing or how their appearance or touching them on the back. Touching is a big thing. Some people are touchers and they don't realize that it could be taken a different way and be offensive. So you're right, Sandy, it is in the eyes of the beholder what is going to offend you. And that kind of goes with there's always that line that if you cross it, you have offended. And that is by that particular person to which you are talking or acting. So work environment, what is a work environment these days? This has expanded under the law tremendously in the last few years. So not only is the work environment where you are, where you perform your duties, or in this case, every village facility, but it's work sites that are off-site, at seminars, at conferences, at employer-sponsored events. You could be in your house and you could still either be a harasser or a harassment victim, depending on, what's going on. We have seen issues arise, especially in the last year when people are at home, and especially when people are at home for a while working, they kind of blur the boundaries of what's work and what isn't, and what is okay to say or do or wear or gesture. So the actual work environment can be anywhere where you might be conducting work or be there for a work purpose. So again, in expansion of the original law on harassment, courts in recent times have found that sexual orientation and gender identity can be the basis, remarks or comments or slurs or pictures, whatever, which relate to a person's sexual orientation or gender identity, can also be sexual harassment. So, that is something that we should be aware of. There is still, interestingly enough, are jokes or comments or cartoons or derogatory remarks about people who are homosexual or heterosexual or transgender. These are all equally protected in addition to what we talked about earlier with the unwelcome comments, etc.
Hold on, Sharon. We have sexual harassment training tonight, and it's going to take about another 45 minutes before the public comment section because it's not a typical meeting. Do you want to wait till next Tuesday, or do you want to wait 45 minutes? Do you want to shoot me an email if it's something I can have prepared in advance too? All right, thank you.
So in addition to what is covered by expanding laws, we include non-employees as well as employees in a workplace. So victims can be employees who you would normally identify as victims, but also non-employees, customers, witnesses who just see harassing situation occur. They are also victims. Vendors, citizens who come in to pay their water bill, and elected officials. I feel like I might be the one of the reasons that was added to legislation, because we our firm and myself were investigating a claim of harassment by one elected official against another. And aside from there being absolutely no evidence of any unwanted touching, but we also concluded that the current state of law at that time actually didn't cover that complaint. And then shortly after that, the law changed. And, you do spend a fair amount of time in Village Hall. You work hard at your job of trustee and mayor and clerk and finance director and every position. So you should be covered. This is your workplace.
I have a question.
Mm-hmm.
So let's say as an elected official, we're out in the community doing our stuff and somebody says that obviously we did something and they did the he said, she said. How do we go about investigating that? Because it's literally their word against yours.
Right. So those are always the toughest cases. And what I always say is that you, of course, and we'll talk about this a bit later, you have to investigate every reasonable complaint. Like if somebody came here and said, oh, Jen was harassing me and inappropriately touching me last Saturday, and you are actually out of town, then that would be the end of that investigation. But if there is a reasonable complaint and it's a she said, whatever, then frankly, absent some extraordinary circumstances, the complaint would not be substantiated.
Okay.
Extraordinary circumstances would be, oh, if there was some video of it, or if if the victim had some sort of, marks or went to the ER and made a report there at that time, which would obviously enhance their credibility, but that's usually it. In addition, I mentioned citizens as victims, and the Human Rights Act, the State Human Rights Act, does protect customers of places of public accommodation. And that is what you are. You are a local government, you provide a public service. So when dealing with the public, both employees and non-employees of the village can still be held responsible for sexual harassment. The definition has greatly expanded in the last, say, 5 years. And that's just probably in response to awareness of how workplaces operate these days. Additionally, citizens can be perpetrators. So you have to be sensitive to the fact of somebody walking in to pay their water bill every month and they make, ugly sexual comments to your staff. That could be sexual harassment for which you are responsible. So while you can't stop what the public says, you can take other measures and you will be responsible. So it's just good to know. So some things to think about as an employer, as a person who works here. You should focus, you should understand that the focus of harassment is the effect of the behavior on the person, the complainant, not the intent of the speaker or the actor. As Sandy mentioned, it's about the impact on the person, not what the other person thought they were doing or saying. Doesn't matter if the behavior is deliberate or unintentional. And every review or investigation is based on reasonable perceptions of the person complaining about harassment, not those of the harasser. So you see, it's really focused on protecting workers, protecting all of you as elected or appointed officials, and not giving the benefit of the doubt based on intent. We don't care what the intent was. It's what is the result.
Can I ask a question on that? What if it's 3 people standing in a room, 2 of them are talking to each other and inappropriate remarks go back and forth? Can the third person also be offended?
Absolutely. And I have a recent example of that. Another client of ours, which will remain nameless, he had hired a new person in a fairly authoritative position and likely in an effort to make friends, was fond of telling off-color stories. And like Amber said, people would laugh and, you know, nobody said to him, hey, that's really off color. We'd prefer not to hear it. And in fact, the client received a harassment complaint from a bystander who on several occasions overheard these really pretty raunchy stories and was the one that stepped up and said, hey, you know what? That's no good. That makes people uncomfortable. And that is also a really good example of how, you know, people really are still to this day not very, they're very reluctant to make a complaint unless it's really bad behavior. Most people still feel like, oh, I don't want to raise an issue. I don't want to sound like the party pooper. I don't want to get in trouble for saying something. And in fact, not only is the complainant always protected, but it's really an aid to the work environment in total. So I think that Amber has a few more examples.
So examples of sexual harassment. The first one is a display of derogatory or offensive pictures, cartoons, calendars, posters, drawings, or videos. So an example I have is we represented a client at an issue with a client at a previous firm that I worked at. There was an employee who was sharing photos of naked photos of his spouse. And that is something that you shouldn't do in the workplace because
Or anywhere.
But
Any help?
that's
Anywhere.
an example of, I don't know why that individual did that, but to a less extreme, I don't know that people hang calendars anymore, but if they do, it's not the place to hang the Hooters calendar or the Playboy calendar in the workplace. Same thing with videos. Luckily, a lot of online videos now warn you beforehand that not suitable for the workplace. So NSFW, it says NFSW on it. That's not the one to email to your coworkers. Sexual gestures, innuendo, comments, and stories. So that goes along with Margaret's example of telling stories in the workplace. The same thing with making sexual comments. And sexual comments sometimes aren't as overt. Saying something along the lines of, you're very attractive, so we think you'll be successful here. That would be to somebody, they might see that as crossing that line that we talked about earlier. Or you look, making comments about their appearance, saying, etc. Inappropriate jokes or slurs, teasing, questions. I know that sometimes we get very comfortable with each other in the workplace. We start to talk to each other like we're friends, and again, you don't know where somebody's line is. So a joke that you read somewhere that's really funny that is inappropriate, or that maybe you're share with your buddies, but it isn't quite appropriate for the workplace. Jokes about things of a sexual nature, etc. Again, you don't know what somebody would find inappropriate, and you know, if somebody is and an example would be, you know, especially if you tell a joke and somebody says they're uncomfortable, that comment of, you know, get a sense of humor, I don't know what's wrong with you. If someone says they're uncomfortable, it's not a joke for the workplace, and you cross that line. Verbal abuse, graphic comments, subjective or obscene emails, letters. I briefly did a lot of doc review as an attorney. That's where, you know, you have mass discovery, and a lot of times you get to read through people's emails. Yeah, don't send an email. You shouldn't, you know, don't send an email saying any of the things that you wouldn't say in person. Making a sexual comment, don't send an email saying, you know, you look really sexy today, or making sexual comments in an email, because not only, if you put in, you know, not only is it harassment, but it's also documented harassment. And you would be surprised the types of emails that I got to read, because again, when you're doing, if you're involved in litigation, when you do discovery, all those emails get reviewed by an attorney. So if you don't want me reviewing it, it's not something you should be sending. The same thing with letters. I don't know if people write letters to each other anymore, but don't put your sexual, you know, don't put your harassing comments in a letter or a memo, a memorandum, a Post-it note.
Just a text.
Don't text this. Don't text
Emoji,
Test
your obscene
pictures,
jokes.
emoji.
emoji,
Yeah.
Emojis, and again, there are emojis that have a sexual connotation. I think most people know what, like, a peach emoji is also seen as a no.
That would be a no.
Okay.
No, I was gonna say,
What?
there's some that I'm like, I don't even know what that means. My daughter would be like, you can't use it. I'm like,
Yeah.
why not? What is
Well,
it?
if
Sandy will explain later.
We'll have a separate
I never
course.
did
on
that.
that.
on emojis to stay away from.
I'll give you a list later.
Yeah, text emojis.
Don't use it, Brenda.
So yeah,
I'm curious.
texting, sexual comments, a inappropriate joke, a link to a website that, you know, it shows inappropriate material, bad pictures of that you shouldn't be sharing them ever. Also is a no-no. Phone calls, harassing phone calls, making comments, voicemails, etc. Are also examples of sexual harassment. And then offensive touching. And this is something that Margaret spoke of briefly. But different people, some people are very touchy-feely. To other people, that could be seen as sexual harassment. And so, for example, I'm not a touchy-feely person at all. So if somebody touches my hand or my arm or my shoulders, I don't know what that means. And I could see that as being an unwanted advance. I've known that people who go up to somebody and just start rubbing their shoulders, you look really tense and you go for the back massage. Well, you might think that that's a kind gesture to somebody else. That could be seen as an unwanted advance, unwanted touching. So when we get into touching, you know, it's sort of a hands-off policy. There's not really a reason to touch your coworkers unless it's like a handshake, a high five, etc. And then after that, you get into what we know is a bad touching, assault, rape, blocking somebody to get out of a room. I think we've heard of that in like the Harvey Weinstein cases, where he would prevent somebody from getting out of the room in order to keep them in there. And I won't go beyond that. Another offensive touching, butt slaps. Save it for the locker room. And again, you know, that there's no it might be, you know, you slap your friend's butts. I don't know why anyone would slap butts, but you know, if your male coworker thinks that that is inappropriate, then you know that's an unwelcome gesture. So those are some
Right,
examples.
so I want to add to this something that is probably far more common in most workplaces, which is sometimes called these days microaggressions. And that would be things like calling somebody a girl, a female worker, a girl, or honey, or babe. The touching on the back, the getting into what we all know is personal space. Now, if that happens once or twice, that's probably not anything. When it happens a lot, it could very well be sexual harassment. And that would include remarks such as, you know, go home to your husband, you know, a remark about women in the workplace or working women, you know, related to their sex, asking about a worker's relationship with their partner or spouse, again, on an isolated basis. These are probably not actionable behaviors. When they happen over a prolonged period of time, they certainly can be. And this is by far the most common complaints that we deal with. As Amber said, people either become very familiar in the workplace and think that all their coworkers or all their subordinates have the same mindset as they do, or they use it as a way to assert authority. And that is exactly what the law prohibits. Sexual harassment is a form of discrimination because it asserts inappropriate authority or power over another person based on their sex, on their gender identity, or on their sexual orientation. And we really have to be careful about that. Even if you're not at the point where it meets the definition of sexual harassment, it really destroys morale. It sours the workplace and it costs a lot of money.
So the examples of sexual harassment aren't just limited to in person. You also have social media, the internet, and so sexual harassment can extend onto social media and the internet. I did have a case once where an employee used his blog, his anonymous blog post, to sexually harass one of his coworkers. So that by posting pictures and comments about this individual, she did file a complaint. And even though it took place in the online world, it was still considered harassment. So, the examples we gave in the previous slide, of making comments, jokes, pictures, etc. It extends onto electronic formats like Facebook, TikTok, Instagram, Twitter, Snapchat. Just like you shouldn't send somebody an email making a comment or unwanted advance, you shouldn't send them a Facebook message or a private message on Instagram or on TikTok or Twitter. Similarly, if you posting something on your Facebook page, some people post just things that they really shouldn't post on Facebook. Well, it's where I express myself. Well, going off on a coworker with photos or making comments about them or how they, that it could also be considered sexual harassment.
So you mean when you're calling out somebody specifically, not them just thinking you're implying it's them when you're, so basically this person's putting a picture or saying it's Sally Sue, they're actually calling them out by name. Okay.
Not necessarily. You
Oh,
want to take
well.
this one?
I'm nodding yes, but you're probably right that,
Depending on how extensive it may be, then they may.
Yes,
If you're pretty
yes.
much if you're describing them but not saying their name versus,
I think, and correct me if I'm wrong, if I don't say John's name, but I'm like, that guy that was at that meeting wearing the blue shirt and the blue hat,
exactly.
we kind of know who it is.
nothing offensive, so it wouldn't.
If it's not,
Or if you're a supervisor and you're just sending general, online messages to your subordinates that are offensive to anyone, yeah, that too.
I have a general rule of thumb. I've blocked everybody in this room on my social media.
I don't even have any.
and if you do that, if you make it private, so that the person who they were complaining about isn't able to see it, you can't really harass them, can you?
Well,
Somebody
that's
with
a really
Snapchat.
I don't know,
interesting
I'm not on social media
question.
either, I don't care.
So, yeah, go ahead.
Well, I think just because you make something private doesn't mean that it isn't seen. Or maybe the person that you're making sexually harassing comments about can't see it, but their coworkers can, and then it comes up in the workplace. I think that people rely too much on privacy settings on social media with the idea that that means that, only my friends and family can see my rants or my comments or my complaints about my coworker who won't go on a date with me. But that isn't necessarily true because depending on your settings, you can still, some settings are friends of friends. So you might not be friends with that person, but you might have mutual friends that allow them to see your posts.
Or if somebody comments on it and they're
Or
friends
somebody
with you,
sees-
then you can see it.
Right,
Wow.
and then they can see
Right.
it.
And remember, it's not about the actor's intent. It's about the impact on the individual.
I remember when I first met Stuart, he said, just remember, when you send it or leave the voicemail, remember one thing, it's forever.
Mhm.
So,
Yeah. and
That's right.
Same with social media.
That is
Yeah, that's what he
especially
meant.
true with social
it's
media.
forever, it's forever.
It's forever. So with social media,
Make it good.
it's not, it's forever. You can subpoena it, it is preserved. And it can follow you around, so.
But some of those things, at least where I work, I mean, if my boss is a female and if she says, oh, I like your cologne, I don't find that as harassing. I don't
That's
find her
fine.
saying, hey, sugar, can you go get me a jug of water? I don't see that, but you flip that role the opposite way, take it the other way. If a man says, hey, sugar, will you go get a jug of, then all of a sudden this becomes honey, whatever. But I don't find those things offensive. So I guess it's all on the person and their ability to either suck it up or cope with. And then you have cultural differences with the way sometimes different cultures speak. Hey, babe, from someone of a different culture to me is the way they talk. That's just the way they carry their dialogue. So I mean, it's all, you gotta let it roll off. I mean, for me,
That's
or
right.
you'll be filing the lawsuit on everybody you run into.
Well, all right, so that is the flip side of all of this. Are we all oversensitive now?
Some more
and-
than others, yes.
Well, and maybe that is true, but there is a great deal of middle ground that we all have to be aware of. And the fact that you are okay with a boss saying to you, honey, go fill my water jug, and maybe touching your arm is okay. You're not offended. But flip it, or, maybe Chris might be. So it's really, again, it's about
Individual.
yeah, and so we have to be cautious.
And I guess one thing to keep in mind is that each individual brings their own experiences. So there might be a reason for why that individual, based on their past experiences with coworkers, maybe something happened that was more than just, hey, honey, go get me water. So as a result, any type of sexual comment, any sort of calling somebody babe or honey or sweetie, or a touch of the arm, or saying, honey, you look really nice in that dress, that, or might, to that person, make them feel harassed, because you don't know what that person's experiences are, where their line is. And I think that each line needs to be respected, because the goal is to have people in the workplace who feel comfortable with their coworkers, who are happy to go to work, who look forward to spending time at work, and as a result of being comfortable are also then productive.
Yeah, and that's really bottom line for you. And you are the stewards of the village government, and it is your job to be aware of it, be sensitive to it, and to enforce it. And a few things that we always say when maybe you're wondering, oh, is this actually harassing behavior or not? One would be, would you be okay if this was broadcast by news media or put on Facebook or whatever? Would you be embarrassed at all if others knew what your behavior was? Or do I want my spouse or partner or other to know I was doing this? If your answer is no, then you should think twice. Or would you be offended if this was done to you or to your spouse or your boyfriend or girlfriend, daughter or son? So here's the really dry part. The primary sources of the law of sexual harassment, Title VII of the Civil Rights Act. It is unlawful for an employer to refuse to hire, discharge, or deprive an individual of employment opportunities on the basis of race, color, religion, sex, or national origin, to name a few. Sex includes sexual harassment. The Illinois Human Rights Act goes a little bit further. It prohibits unequal treatment, unequal terms and conditions of employment, including hiring, selection, promotion or lack thereof, transfer, paid tenure, discharge, and discipline on the basis of or perception of sex, gender status or gender identity, and sexual orientation, to name a few. But in terms of harassment, our state law identifies or describes harassment if it's based not only on your sex, but on your gender identity or status or your sexual orientation.
Can I ask a question on that?
Mhm.
Quasi off topic. I
Yeah.
saw something come out from the governor's office today about equal pay, I guess, I didn't read the whole thing, so I didn't know if you had it. It was,
I have not yet.
all right. So he did something again today to try and make it equal pay without discrimination based on sex or biases. That was the
Stay
headline I
tuned for a
gathered.
blog.
All right.
What did you-
He-
Equal pay for what?
He was trying to, from what I gather from my brief 2-second synopsis, do not hold me to this. And Margaret, I'm sure we'll have somebody at Ansel Link write something way better. But it essentially was trying to equal the playing field on pay based on gender. Because women and men still are not equally paid. And so he signed something that was supposed to help with that or along those lines. It came out late this afternoon, so I didn't know if you'd had a chance.
No, I have not. How about you?
I have not.
Yeah, but we'll report on that. So the inclusion of the word perceived, why is that so important? It expands sexual harassment. It includes whether the harasser thought somebody was transgender, homosexual, was a man or a woman, whether or not that is true. So now that is harassment. Do you wanna?
I guess I'm not trying to be funny, but sometimes you just don't know that a man is a woman or a woman is a man.
Right.
How could you be held accountable for something you're not aware of? You'd have
Well-
to prove that you were aware that she was a he or he was a she. I mean, you know what I'm saying? You cannot tell. I'm not trying to be funny. I'm not trying to be anything. You cannot tell sometimes. So if you make a comment, I mean, how can it, if you didn't know?
So,
Perception is just what that person believes it.
yeah.
That's how they.
And there would certainly be a factor, but it's really more about an example such as this. You make a lot of homosexual remarks or slurs to somebody because maybe you believe that they are or they are not themselves homosexual. And your perception is wrong, but nevertheless harassing. No, the trick here is that every case is very specific on the facts. There are hundreds of cases, court decisions, and they're all individual fact patterns. And you learn a lot that way, but every case is different. And you really have to look at the facts of every case, which is also scary because unless there is a case out there that matches your facts identically, you might not really know what a court might do. So again, stay way opposite, way away from that line. So retaliation, like harassment itself, is also prohibited. So that means any adverse action, demotion, cut and pay, suspension, lack of promotion, being frozen out at work, for instance, because you made a complaint, is as bad as harassment itself. And that is not only protected by the two laws we just talked about, but also by Illinois Whistleblower Act, the federal version of that, as well as state laws, including the Workplace Transparency Act, a relatively new Illinois law.
So, we mentioned before that if you get to the point of it being in violation of the law, that there are remedies for sexual harassment, and these remedies include right to a jury trial with potentially high damages, compensatory damages for pain and suffering, compensation for lost wages and missed career opportunities, so includes back pay and front pay, punitive damages, attorney's fees and costs, and individual liability. And I think the point of this slide is, to the consequences of having a workplace that where there is sexual harassment is that it can be very expensive if you have one of these claims in court. Employer liability. So employers are liable for quid pro quo sexual harassment by a supervisor, even if they didn't know or have any reason to know of the harasser's behavior. And employers can also be held liable for hostile work environment harassment by a supervisor, even if they were unaware of the conduct.
Does that include things that are done not in the workplace? So in the social media on their own time, if something were to happen, would that still qualify?
Well, to an employee of yours or a vendor or a resident, if they're doing it as an employee.
So that the quid pro quo happens even outside of work, then it would still
Yeah,
fall under the umbrella of.
So
yeah.
if your supervisor or employee or supervisor sends a Facebook message to the subordinate, if you go on a date with me, I'll make sure you get that promotion, then the employer is still
liable.
right. Similarly, if your supervisor, somebody who has, can negotiate contracts or pick out vendors, sends an email, you're gonna get the work as long as you do the following. Even if the employer doesn't know about it, they'd still be liable.
Can I ask a question? I don't know why I say that and then ask it. William does this a lot, which is separates himself as a resident from a trustee, and he will say, as a resident, this is how I feel. So if somebody were to say, as a resident, and then harass someone, is the village then still liable?
Are you trying to call me out?
No, but you're the way
Well,
you
yeah.
actually
Examples, please.
you do it. You do your separation of duties very well when you're commenting in the public forums. But that's why I ask, if somebody were to keep that separation of duties in line and then do the harassment, is the village still liable?
See, I think that's very risky
All right.
because you cannot
Where I
always
live.
draw that line. And it really is about, have you created, whether, you say you're just speaking as a resident, if you have created a hostile work environment or behaved in a, quid pro quo fashion, yeah, you're going to be liable.
Is the village still liable? then?
Yeah,
All right.
Just for clarity, I don't do any of that.
No, he doesn't. No, he's,
we're
but-
just taking it.
Sorry, William.
But the disclaimer is, as a resident, doesn't save you.
that's
Right,
what I was asking.
Doesn't
Yeah.
make it personal.
All right.
right.
No. And you can't.
What about all due respect?
That means you
No.
have
Yeah,
no respect
that's
at all. when
like,
you-
I'm about
usually
to,
wouldn't.
really- I'm about to eviscerate you, so get ready.
Did you have a question, Brenda?
Signature.
Well, that's true.
So a lot of the trustees have full-time jobs, so is their other job also responsible?
What was the question, Brenda?
The other most of the trustees have employment outside of the village, so is the other job also responsible?
But you wouldn't be here representing another job.
Right, right, so,
But you could be harassing someone in not a job format still.
Well, the-
That would still qualify, correct?
yeah, see how this is so
So if you had a
complicated?
coworker come to a village meeting
Yes,
and you sexually, then you got both.
They look for deep cuts.
bingo,
You're broke.
And-
you go where-
yeah,
Yeah, so then that
Yeah.
could happen. You have a coworker at your other job that you call babe, honey, sweetie, and every time you see them, you know, rub their shoulders, and that person finds that to be harassing. And then they come to a meeting and you say, hey babe, glad to see you at the meeting, so glad to see you, a shoulder rub, looking hot in that dress. There you go.
So don't say any of those things, please.
Don't put it in a text message. Or in a Facebook
Hey,
post,
I
or in
thought-
Instagram, instead.
Back to
Don't slide into
masculine,
any
Alright.
DMs.
Quit collaborating
So-
things is basically what it boils down.
get your, and then it will be a subject of FOIA on top of that.
Yeah.
So that's like the triple whammy.
Here's the other thing about those text messages, now that Margaret says this, and I share this with our employees when we do sexual harassment training here with the employees, which is most of you have cell phones that are village cell phones. And yes, personal business is not foiable. However, somebody has to look through that to determine that that was personal and not village. So if you don't want me or Margaret reading the text message, please don't put it on your village phone
Or
Certain
delete it.
apps.
or apps or any of that, because either Ansel Blank or I will have to look at it to determine whether it's village business or not.
Yes.
Right.
Most phone companies delete text messages after so many anyway.
I think it's like 30 or 60 days. It's days, not amounts of text.
And I mean, just a whole different subject, but a multi-billion-dollar company is going to protect that, not giving up information about. I would think they would.
I don't
protect
think
that
that's
like-
accurate. He's saying that the phone company won't give up text messages.
They will by
Yeah,
subpoena.
subpoena.
Well,
We send a subpoena to the phone
we see how well
company.
Verizon moves. So.
Well,
Same with the-
So I mean,
Totally
when you
messed
got
up.
two Verizon against each other, they're all going to move. it.
They
And
are
I
a pain in the
I
ass.
think I've had to subpoena text messages in cases. And the same thing with phone records. So let's say, you know, to somebody's point, it's a he said, she said, but you're making, you know, lots of phone calls to this individual's phone. Well, those phone records are discoverable.
that's how I look at it, John. Don't put it on your village cell
I
phone
don't
if you don't
co-
want me or
I'm
Margaret
not gonna
reading it.
collaborate. I'm not- I don't do that stuff.
Okay, so supervisors, which technically you all are, because you all have a department or an area of authority or a recommended authority. So you all serve in the capacity as a supervisor. You make decisions about employees here. So be aware that quid pro quo behavior will result in your personal liability. That means the village's insurance will not defend you and will not pay any award. So that's pretty serious. And in addition, it creates real workplace problems. So again, employees can be sued individually by the victim and obviously can be in trouble at work and probably at home. So what can you as bosses and, people who work for the village, if albeit in an elected or appointed capacity, do about harassment? Review the policy, discourage conduct which violates the policy, and most important, you are all bosses, so you are obligated to take formal action when necessary. Don't sweep something under the rug. Don't say to yourself, not my problem, or I don't want to get involved in this, because if you know about it, likely the entire board will be seen as knowing about it. You are individual agents for each other. So you should, if you see that kind of behavior, you should report it. You should report it to Brenda or Sandy or Rick. Because action has to be taken. I'll tell you this, it's almost as bad to do nothing as about a complaint as it is to actually engage in the behavior. We like complaints in writing, but you cannot make further action on a complaint conditioned on it being in writing. Anyone in authority at the village is appropriate to report to, but primarily the village president. We have outside agencies that employees or others can report to. We'd prefer to avoid this option. We'd prefer to resolve issues internally. False or frivolous complaints, we hear this a lot. What about employees or others, elected officials comes to mind with the touching of the bud that didn't happen. What about this? What is the consequence for false or frivolous complaints? And how do you strike that balance to encourage reporting of problems with, oh, if you're not right, you'll be in trouble. So by law, if an individual makes a complaint knowing it's false and doing so to accomplish other goals, it is most likely, most certainly frivolous. And in that case, you should take discipline against that person. But it does not include charges or complaints where the person might just be wrong or made the complaint in good faith. There are serious offenses and should have serious consequences. So if you learn of harassment in the workplace with employees, vendors, citizens, whatever, don't dismiss it, especially be aware of situations or behaviors which could be sexual harassment. A lot of times people don't use those words. So you have to be sensitive to what you're hearing and know that, oh, I think that this complaint is about sexual harassment. You should always listen carefully and then promptly take action. Actions to investigate, and do not do this on your own. But what will happen next is that the complainant will be interviewed, will identify and interview all witnesses, will review texts or documents, will interview the alleged harasser, and we will document all of that. And what we're really aiming for is to correct the problem. So appropriate discipline action, separating the individuals. In the case of the citizen who comes in, or resident, I should say, to pay his water bill, who every month says something nasty to the staff, you know, maybe they're going to be told to mail their payment, or somebody else is going to take care of them when they come in. Those are appropriate actions. No, you should always also, of course, follow your policy. And sometimes people just need to be reminded. You know, so training, review of the policy, a session like this can just get people back on the right track. Final thoughts. It's work. So, you know, remember, people should be behaving in a professional manner. Sexual comments, conduct, behavior, think about how it's always inappropriate at work. Is you cannot go wrong if you follow that advice, and you encourage others to follow that advice. Behavior related to sex, gender, orientation, sexual preference, always inappropriate at work. So if you see it, that should trigger something. And that's it. So any more questions, Sandy, with your finger up?
Do they have to take sexual harassment training yearly? Because I know our employees do.
Yes. This body should be trained every year.
That's mandated by law.
Yes.
Does it matter where you get the training?
No.
Ah,
So if I do it at work with my
Done.
job. I
Chris
have to
and
take it.
I'm out.
William are
Yeah, I
both,
was gonna say.
you can stay. Chris and William both work for public entities outside of this public entity. And so
Mhm.
both of them were like, do I
So-
have to go? I said, please do this
My,
time.
my PEO requires me to give this to my employees and I have to participate in it as well. So does that count?
They're all
I did
trying
mine
to get
at
out of it.
Rick,
Oh,
you're
and
the
you-
I'm gonna do it
No,
twice.
we're
I
trying
wanna
to
have it on
save
record.
money.
There's nothing wrong with too much training.
We have a video.
Bam.
are you kidding? The training I go through every
No
year is
such
way
thing.
more.
Real
expensive.
training's enough.
Or
Yes.
there's no such thing as too much training, yeah.
Yeah. So he works for a university, so he gets way
I
more.
get all kinds of.
Oh, you probably get.
There's like
oh,
22 things. I work at a grade school that we have to go through every year.
He lives in the woke culture.
So well, then my question to that then is, do we need to keep reps
Yeah,
of that?
so it is an employer obligation to train. So cooperate and attend.
Okay, and So if next year we wanted to do just the video and then have you come every other year,
Yeah.
we could just send them the video
Yeah.
and ask them to do it. If they do training outside of this, can they give us proof and can we call that?
I got a
Yeah,
certificate.
Yeah,
You want me to
that-
print- you want me to print it?
That could be sufficient, but I would want real actual.
It'd be better just to be
eh,
here.
Yeah,
Sure, this does.
Yeah.
Well, like the online one that we use for our employees, gives out a certificate at the end.
so maybe that's okay.
Better.
Yeah,
Andy? As a group and I have a goal.
Yes. Yeah, we do that too. So
What's this,
the employees, we just
All the
have lunch
employees.
and we make them all watch the
Yep.
video together.
what's the state statute that covers this?
oh, that
Oh,
is
I get
the
that here.
workplace transparency
Let
act.
me
Is
see.
there a state statute though?
Yeah.
Hold on, workplace.
Workplace transparency act.
I still have the email from my
Fairly new that it
PEO.
became
It
yearly a
is,
requirement.
yes.
Because Brenda and I are only on like our second or third year doing the training here and there.
So how,
Huh?
What, it
She
was
needs a good
my
reading.
reaction to me
No,
too.
but I'm gonna read it
Yeah.
over, see if I'm exempt or not.
State
So-
reaction to the 22.
Saying I should is one thing.
how does a $20 an hour employee afford an attorney to bring something like this forward when your EEOC is useless?
Well,
No,
EOC,
It's not.
well, yeah,
My-
they
my
are
experience,
free. And many lawyers will take this on a contingency. So you'll pay me a third of what you recover.
Because I'm starting to feel like salt instead of sugar, you know?
That's nice.
hey, John,
Yeah,
having been on the complainant end of this and going to a lawyer, it works.
Yeah, but the EEOC is the same agency that just relaxed a lot of things over the last
One is
18 months.
contaminated pen.
and Amber points out, which is important,
Yeah.
John,
Yes,
that the law allows for the prevailing plaintiff, so they have to win. They can collect their attorney fees.
And they don't even have to win huge damages. They
Oh,
just win on one count. and
I don't
they-
mind being called sugar. But a lot of people though, Rick's situation, I mean, I suppose, I don't know which way the percentage would lean, but the average person would, one, not know even know how to start the process. Secondly, may or may not be able to afford it. And no offense, if they're in a big fish at the end with money, no offense, you attorneys have to be paid as well, unless somebody's just going to do it because it's a good cause.
I don't have
It
this.
just seems
Please don't
unbalanced.
sign on my
Very
table.
unbalanced.
Attorneys who handle these cases, who represent plaintiffs.
Your table?
They take
The freebie?
because they, when they win, they'll get attorney's fees and also possibly a percentage of whatever damages.
If they.
Yeah,
If they win.
if they win.
Right.
Yeah,
But.
The
I
protections
can't
just
say
seem
whether I
unbalanced.
want it or
I'm
not.
sure they wouldn't be taken if they didn't think they had a good.
Bill,
right. So
Right.
you know
Bill?
what? That is
Do you have any
one
other
of our first ways
The bill
that
sign
we
that?
evaluate a
Yeah.
case.
oh, I thought you were
Yes.
leaving.
You know, representing defendants, we look at, do they have a lawyer? And if they do, we know that, you know, maybe there's a little bit more than an unhappy employee.
Because, you know, with all the cultural diversity that seems to be the big push, there's us who are at the other end of that, in a way, feel discriminated. You know, the company I work for, I mean, you know, if you're a heterosexual, good luck getting promoted. So I feel that whole role is really reversed, in my opinion. I mean, that's just the whole culture and, you know.
Chris, they didn't give me the statute. It just says Illinois mandatory training.
But it's public access
It
to
is.
101st General Assembly. I'm reading it.
Okay.
Chris likes to read the law.
Okay,
read
well,
it over?
good luck with
Yeah.
that.
He finds it interesting.
John.
He actually asked me for the
So,
Illinois Constitution.
being-
I told that to him too.
White male over 50,
We're just out of luck.
heterosexual.
We're out of luck.
I documented 17 accounts of places, times, dates, who was there. And they interviewed 15 people who corroborated everything.
Yeah.
But I can't say what the outcome was.
I just go back to Indeed.
I did briefly look at what I had asked you earlier about what the new change was.
EEOC,
And it
that's the same
appears-
agency that-
And it appears as if any large Illinois business now has to report equal pay information beginning next year, and they will have to tell the Illinois Department of Labor listed the employees during the past calendar year that were
Ready
separated by
for a
gender, race,
motion to get out of here?
ethnicity, what they were paid,
Sue
when they
Sandy,
started.
Finishes her question.
So
Oh.
they're gonna be checking for
What?
equal.
What is a
Doesn't
large
start till
employer?
24.
It doesn't really say that. It said next year.
No. Tram is
Sandy?
Yeah,
2024.
This says 20.
okay, Amber, get on
Sandy,
that.
is that Glenda? Sandy. Glenda.
Yes, Glenda, did you have something?
Does the zoning board need to take this training?
Yes, I will email you guys, though. You're not gonna have formal training in this style.
Of course, you just attended it, so maybe you could
Yeah.
sign off. Say,
Glenda's our zoning board chairperson.
So if that concludes the training, I'd like to thank Margaret and Amber for
Yeah,
coming out
thank
tonight.
you.
Sure,
And,
pleasure.
Anybody on the board have anything?
Tram Day, March
The motion.
2024.
We got public yet? Public?
What is this?
No, that was my last question.
There you go.
I think use this one.
Yeah, use the portable. There you go.
Got a question for William. Did we have a balanced budget this year?
At the end of the fiscal year.
Well,
Maybe for the next 2020, 2022?
yeah,
The one we're proposing, one that was passed,
yes,
it is proposed, yeah, we passed.
Yeah, it's balanced.
balanced budget didn't go over this year.
You asked me a question.
Well, you won't know
You
that
asked
till next
if
year.
the one we just passed. the
Yes.
2022 budget, is it balanced?
Yeah,
We passed the balanced budget, yes.
okay, so this year we did. Last year we didn't have one.
Once again, 2022 budget that we passed.
Okay.
We
Yeah.
presented,
year
it.
is
we
not-
won't know if it's
Till
balanced
next
until
year.
the end of next year when we're done.
Okay,
All
right. that was all I would need to know.
Yeah, the proposed budget.
Any further comments?
Motion to adjourn.
Second.
John makes a motion to adjourn.
Nah, it doesn't go into effect.
All in favor, say aye.
Hey.
Any opposed, same sign. We are adjourned at
It says-
8:02 PM.